Now, I am going to dictate a legal passage based on Calcutta High Court Appellate Side's judgment at the rate of 160 words per minute. Let's start. The instant appeal has been prepared against the judgment and award dated 13th August 2018, passed by the learned Judge, Motor Accident Claims Tribunal, 3rd Court, Nadia, Krishnanagar, in MSC case number 271 of 2015 para. The brief facts of the case is that the victim of this case, namely 1. Dev Kumar Saha, on 28/7/2015 at about 3:15 p.m. when he was going towards Chapra side from Krishnanagar side, riding on his motorcycle at the time of the offending vehicle number WB23/9032 track, which was going toward Krishnanagar side from Chapra side in high speed in rash and negligent manner. The driver of the truck lost control over the vehicle and dashed the victim along with his motorcycle. As a result, the victim sustained multiple injuries over his body and were shifted to Nadia District Hospital, but the doctor declared him dead. Para. The widow, children and the mother of the deceased prepared an application under section 166 of MV Act before the Ladi Tribunal for getting compensation on the ground that the accident caused solely due to the rash and negligent driving of the offending vehicle duly insured under the policy of the insurance company. Para. The claimant's case was contested by the insurance company by filing written statement. Para. After hearing the parties and after receiving the evidence, the Ladi Tribunal has awarded a sum of rupees 3,69,500 in favor of the claimants and directed the insurance company to pay the compensation. The insurance company has satisfied the award through the office of the Ladi Tribunal. The claimants have prepared the instant appeal for enhancement of the compensation. Mr. Roy, Ladi counsel, appearing on behalf of the appellant, submits that the award passed by the Ladi Tribunal is erroneous. The calculation of the compensation in this case by the Ladi Tribunal is not justified and not in accordance with the provision of law. He further submits that the income of the deceased as assessed by the Ladi Tribunal is completely erroneous. In this case, the Ladi Tribunal has adopted the income of the deceased nationally rupees 3,000 per month, while the deceased had a business of a Mrs. Dipta Bostro Biponi, where from he used to earn a huge amount of money and had filed the income tax return to the concerned department year after year. He further argued that the income tax returns were submitted by the claimants before the Ladi Tribunal and these returns were sufficiently proved through the person's income tax, but the Ladi Tribunal has erroneously not considered the income of the deceased on premise ground. He submits that the claimants had filed the income tax return of the deceased for the assessment year 2012 to 13, 2013 to 14 and 2014 to 15. Amongst them, the income from assessment year 2013 to 14 is the highest of rupees 1,97,490. Mr. Roy further submits for the purpose of assessment compensation under section 166 of the MB Act, the highest annual income of the deceased bearing income tax return has to be considered as an income of the deceased. In support of his contention, he stated decisions of the Honorable Apex Court passed in this case is superior. Mr. Roy further submits that the Ladi Tribunal has also committed error in awarding the compensation, wherein the deduction towards the personal expenses of the deceased was made 1/3. It should be 1/4. He further argued that the Ladi Tribunal has failed to award the future prospect and general damages in this case. According to the observation of the Honorable Apex Court in National Insurance Company versus Pranay Shetty, Mr. Chakraborty, Ladi counsel, appearing on behalf of the insurance company, refuted the contentions of Mr. Roy and submits that the Ladi Tribunal has observed the reason. Stop. Thank you.